Before we begin today's topic, today is about the corporate customers. Before we begin, can I know the background of your working areas? Can you type them to me so that I could perhaps see? Anyone who has been in the credit area for say less than two years? Can you please let me know? If you could respond, it will be easy for me to carry on the session. Thank you, Laksiri. You're from the Corporate Banking Division of Commercial Bank. Others seem to be who don't have any perhaps credit background, is it? Thank you, Tyagaraja. So out of 13 people, right. Thank you, Shahani, Akila, Kasun, thank you. Amma, great. So we have 1, 2, 3, 4. Yeah. We have quite a lot from the corporate divisions as well as the credit department. So basically you, I believe, have some basic knowledge on credit as well as how things, how the legal aspects work at your departments. Yes, right. To begin with, today's topic would be the corporate customer. You would know that your customers in the corporate world who are in the corporate banking division plays a major role in your bank. They are the most valuable customers for you. So perhaps the company, the bank might look at different aspects in categorizing these corporates. Maybe it is different from bank to bank, but yet they are large. The corporate banking, corporate customers are rather quite different from the retail customers. I'm sure people who have worked or who are working in the retail banking would know the needs and wants of a retail customer as well as a corporate customer. In your experience, can you let me know what are the unique features of your customers, people who are working in the corporate banking divisions? Can I know? What are the unique features of your customers when it comes to any aspect that you could come out with? Any uniqueness that you feel? Can anyone give me a feedback?
Madam Laksiri.
Yes, Laksiri.
Highly demanding. Highly demanding.
Very good. They are highly demanding. Yes. That's one of the, traits, I believe, of a customer. Right. Anything else?
Always go for special rates, special commissions.
Right. Right. They always go special permission, special rates. What else? Anything else?
Request for unsecured facilities.
Request for unsecured facilities. Right. So you say that they request for unsecured facilities, they are highly demand, they highly demand. So your knowledge in your legal knowledge in the corporate banking sector would help you in achieving perhaps to give a better service, rather to give a better service to your customers. Now, you know, they are large corporates. They have been in existence for a longer period of time. They would come to you for unsecured facilities. Basically, when they come for unsecured facilities, you need to advise them as to how you could cater their requirement, as well as how you would cater your bank's requirements. You need to strike a balance between the two. Apart from that, you say they are highly demanding. When they are highly demanding, you need to be a little flexible in order to cater their needs. Now, when it comes to the legal platform, laws are there. Your legal perhaps guidelines would say, you need to take this, you need to take that. There will be a list of things. But if you know the crust, the reason behind why you need to take a certain document, why you need to take a certain security, and perhaps when the customer tells you, no, I don't want this particular, no, I don't want to give you any security, you need to know, with your flexibility, with your little bit of knowledge on the legal aspects, how to meet the ends, right? So this is why this perhaps few hours is going to be important to you, right? So we are moving on to our slides, right? What is KYC? Can anyone give me an answer? This is very common. As much as you interact, I would be very happy, because I am in a classroom. If you would see about a large classroom with 100 odd empty seats. So I'm here teaching, perhaps physically teaching to the walls. Unless you interact, you talk to me, you type to me, I will also be bored, and perhaps won't be able to give you the maximum out. So please talk, please raise your questions. Any question I would take up. Please disturb me while teaching, while giving you the session. Otherwise, it is going to be a bit of a one-way conversation. Right. Thank you, Nimali. You had said know your customer. Yes, you should know your customer. Why should you know your customer? Why should you know your customer? Is it something new, or is it something old? What do you feel?
Otherwise, we don't know their lending requirements.
Yes, you will not know the lending requirements. That is why it is important. Is it something new or is it something old? Recently, if you see the central bank guidelines, you would see it is kind of a law, kind of a regulation which has been centered out. But in actual circumstances, it had been there in the past. Basically, you should know the breadth and the depth of your customer in order, as you very correctly said, that for you to cater the needs of the customer, right? So what are the other reasons that you would say that, what are the other things by knowing your customer? What are the other things that you could find out of your customer? Any answers?
The anticipated
Yes,
volume.
the anticipated volumes you can find out. What else?
Source of
Sorry,
funds.
the sources of funds. Good. Yes. We have another answer here to whether we finance a legally acceptable business purpose. Very good. This is very, very important, Kasun. You need to find out whether we are funding, whether we are going to finance a legally acceptable business and a purpose. Why do you think it is important nowadays? Any reasons do you feel that KYC is important today? Exactly, yes, yes. In order to avoid money laundering, laundered money, right? So this is why we need to know why we need to know your customer. We need to know our customer. Now, when it comes to corporates, we have corporate customers. What are the type of corporate customers do you find? What are the type of corporate customers?
Limited liability companies,
Yes, you have
partnerships,
very good.
and sole proprietorships.
Great. Yes. You have sole proprietorships, partnerships, limited liability companies, so forth and so on. Now, you need to understand being in the corporate bucket, it need not be an incorporated company. It can be a sole proprietorship or even a partnership for that matter. So what is important is not the type of incorporation or not the type of incorporation, but perhaps the size and the business that the companies do, right? So we will take one by one and see what are the unique features of these entities rather, and see what are the salient features of those, right? So we move on to sole proprietorship, right? Anyone can anyone tell me the characteristics of sole proprietorship? Anyone or anything that you know about sole proprietorship? Can I know anything that you know about the sole proprietorship?
It's a company that's owned by one individual,
Right.
and on the particular business.
Right. You say that it is owned by one person. By the very name of it, it says, yes, sole. Sole means one, proprietor means the business. One person owns the business. So when one person owns the business, what do you think of the profit? When it comes to the profit, does he need to share his profit? Does he need to share his profit? No. Yes, he doesn't need to share his profit. When it comes to liabilities, is there anyone for him to share the liabilities? Is anyone? No. Yes. Then in that case, you say they are personally. Can you see the board? No. Okay, then I will perhaps. Now, can you see? Can you see the board? Yes. They are personally liable. They are personally liable for their profits as well as their liabilities. Right. Now, when it comes to incorporating or perhaps getting up a sole proprietorship, what do you think? Is it easy or difficult, or what would it be? Since there is one person, it would be an easy task. Yes, there would be less forms to be filled. When it comes to sole proprietorship in Sri Lanka, you need to register your sole proprietorship and you need to obtain a certificate. And with that, your customer would come to you, right? So you would perhaps open your account, and when you are looking at perhaps facilities or facilities to the customer, can you go for perhaps large facilities, as in the case of a corporate, or as in the case of a company? Can you?
No.
No. Yes, because maybe it's too large for him to bear. If he's at a loss, he may not be able to perhaps settle the dues. So when we say that particular customer is personally liable, that means his personal assets also we can take into consideration if the facility is defaulted, right? So when it comes to execution of documents, what would the customer have in his hand? He would come up with a seal. Have you come across sole proprietorship customers coming up with a seal?
Yes.
Yes, right. It's basically a rubber seal, isn't it?
Yeah.
Yeah. So what is generally written is sole proprietor. It says in the seal, sole proprietor, this particular company. That's how it goes, right? And So here he places his signature, right? When it comes to now typing of documents of a sole proprietorship, what is the method that you would do? You know, in each of these entities, whether it's a sole proprietorship, partnership, there is a different way of typing your security documents, right? So when it comes to the sole proprietorship, it says, how does it go? Say Kasun Motors of this address Kasun Fernando, right? Of this address, sole proprietor of the business carried on at, here you get the address and here you get the name. That is how you should type when it comes to sole proprietorships, right? Any questions that you would that you have come across in respect of sole proprietorships? Any questions? No questions, right? Right. Next, we move on to partnerships, right? What do you know about partnerships? You have come across partnership companies. What do you know about them? Any answers that I could get?
Two or more people should be there in a partnership.
Yes, that's right. The minimum number that should be there in a partnership is 2, right? 2 or more. When you say 2 or more, what is the maximum limit that a partnership could have? I get an answer of 50. What else? Any other answers? 7. Anything else? The maximum would be 20, right? The maximum would be 20. So between, you could have partners between this figures, right? So when it comes to a partnership, generally, a partnership is registered at the local or at the local authorities. So once the partnership is registered, you have a partnership number. They are given a number, a separate number. Now, when it comes to a partnership, say there are 3 partners, A, B, and C, right? What is the liability of A? What is the liability of B? What is the liability of C? Would you have any idea about the liabilities of these partners? If something goes wrong, to what extent are they liable?
The percentage that they have invested into the business.
Yes. The percentage that they have entered into the business. Right. Okay, that's one answer. Anything else?
As they have agreed in the partnership agreement.
Right. As they have agreed in the partnership agreement. Yes, according to the share percentage. Yes, and as agreed. Yes. So they are, what do you say? They are jointly and severally liable, right? Maybe as they have uh, agreed to in the partnership agreement, or to the amount they have invested in the property, in the business, they are liable. Generally, what is the capital rather that you should, what is the minimum capital in the books, in the laws, that where partnership needs to be registered? Any idea you all have?
1,000 rupees.
Yes, that's right. It's 1,000 rupees. If it is more than 1,000, every partnership has to be registered. Just for your information, this does not come from the Partnership Act. It comes from the Prevention of Frauds Ordinance. This is a requirement under the Prevention of Frauds Ordinance, right? So when it comes to perhaps executing documents, you have 5 partners in this particular company. The accounts opening mandate says any of the 2 partners can sign. So when it comes to signing of, say, your loan documents, what is the situation? Can 2 sign, or how would you all take it? Who are the people who should sign? Say there are
All
5.
should sign.
Sorry?
All should sign the document.
Exactly. All should sign. Every partner should sign, right? Maybe the mandate carries, the accounts opening mandate will give you instructions for the bank account purposes. But when it comes to documentation, maybe your loan documents, maybe your mortgage bonds, for those, you need to bring all your partners down to the bank and get their signatures, right? Say, if one partner is unable to come, then what is the recourse?
They can appoint power of attorney.
Yeah, they can appoint a power of attorney. That's generally under the general law. Now, tell me, when it comes to a power of attorney, any person can be appointed as an attorney. But when it comes to partnership business, who is the best to be appointed? Who is the best to be appointed? Any answers? Any guesses? Who is best to be appointed? You can appoint anyone, but who is best to be appointed? Yes, another partner. Thank you, Kasun. It is another partner or the existing partner that you need to appoint. In some companies, I have seen that say there are 5 partners, 4 of them have given the power to the elder brother, maybe say most of these partnerships are of family businesses. Maybe the brother and the sister, the brothers and the sisters get together. Perhaps, or the balance four of the partners have given their power of attorney to the existing partner, who is the elder brother, right? So that's all right. There is no issue over that as far as the power of attorney is in order. Now, at this point itself, we will speak about those little nitty-gritties. Anything that you know about the power of attorney? What is the reason for that, Hasalaka? Hasalaka, the reason is that every partner is an agent of the other, right? Every partner is there is a concept, there is a legal concept where when it comes to partners, every partner is an agent of the other, right? So it is always best, rather than to bring in a new person in, it is always best, and it's always recommended, highly recommended, to bring in the existing partner, right? Hope that answers your question. And what were we talking about? We were talking about the power of attorney, right? What do you know about the power of attorney? Anything that you know about the power of attorney, can you let me know? I'm sure you all have dealt with power of attorneys right throughout your corporate banking careers, or perhaps your retail banking careers, or perhaps your banking careers. What do you know about them?
There are two types, general and special power of attorney.
Right, yes, there are two types, general and special, yes. Special power of attorney for a specific purpose has to be executed, which is acceptable to the bank. Yes, Kasu. Right. Now, the fact that a customer comes to you with the power of attorney, is it sufficient? Is it sufficient? Customer says, I have a power of attorney. This is the power of attorney that I have received. I can sign on behalf of perhaps the principal. How would you how would you handle a situation like that? When a customer comes and says, I
Get
can
the
sign
legal opinion. Get the
Right.
legal opinion.
Right. All what you need to do is, you need to know what is the power that has been delegated to the attorney, or what are the powers, right? If that power of attorney has been given by the principal to deal with his house when it is being rented, right? And that power of it, the attorney brings that power of attorney to you, you can't accept that, because there had been no intention of the principal to give those powers to the attorney, right? So as you very correctly said, you need to seek legal opinion, right? Now, even when you go through the power of attorney, when it comes to power of attorneys, they are not very much magic, or perhaps not rocket science, or perhaps not very much in legal jargon. But when you say read them, you will understand that the powers are given to the basic powers I'm referring to, maybe to open an account, perhaps to take a loan, or perhaps to sign on behalf of the business, so forth and so on. you basically, what I want you all to understand is, when it comes to a power of attorney, you need to know whether there are sufficient powers to the attorney to sign on behalf of the principal. That's very, very important. I here have a question as to whether a power of attorney must be registered. Well, under the normal law, under the power of attorney ordinance, registration of power of attorney is not compulsory at all. But banks do require all power of attorneys to be registered. I repeat it, registration of power of attorney is not compulsory under the law, but many banks require power of attorneys to be registered. So you need to find out what your bank's policy is. Perhaps stick to that policy rather than any deviation on that, right? So when a customer comes to you with the power of attorney, does he necessarily need to bring the original, or should he bring a photocopy? How can that happen? I mean, what do you think about it?
He has to bring the original side.
Yes, he has to bring the original. He has to bring the original. That is the document that gives him the power to sign on behalf of his principal. That is the document. The fact that he has forgotten at home and it has been lost does not give him any power at all. Sometimes customers come with certified copies. Have you all accepted those under the circumstances? Generally, you should not accept certified copies. You should always see that the customer has the original with him, right? So,
Excuse me, what is the rationale behind banks asking the registered power of attorney if the law says it should not get registered?
no, it doesn't say that it need not be registered. The law does not say that it is not mandatory or registration is not required or something like that. But you can register the power of attorney. It's not that if you don't register the power of attorney, it's not valid. It's not something like that, right? Even if a power of attorney is not registered, it's still valid. But if you register it, you have a trace over that power of attorney. There is a unique registration number given to that particular power of attorney. Now, why are banks insisting perhaps on this is there can be perhaps a lot of fraud which are happening when it comes to power of attorney. Right? There can be lots of frauds. If it is registered, it gives you a bit of a strength rather than it is not registered. Because the moment you register, because the principal itself needs to register the power of attorney. It's not the attorney, right? Under the law, what is required that the principal should register the power of attorney and give it to the attorney. The reason is, when you cancel the power of attorney, in those registers, your cancellation also takes place, right? So At one point, you could see whether, if really a necessity arises, that whether the power of attorney is in fact registered, whether it's the registered power of attorney is cancelled. So those are the things that perhaps the banks had looked at in requesting power of attorneys to be registered. Does that answer your question?
Yeah, thank you.
Okay. So so that's the original of the power of attorney. The customer needs to bring the original of the power of attorney. When it comes to signing of documents, there is another particular document that you request from the attorney. What is that? Along with the power of attorney, there is one thing that you request. Any guesses? Have you heard of this word, this document? Have you heard of this document? Affidavit? Yes? When an attorney comes to you, you take an affidavit. Have you all taken affidavits? Yes or no? Yes or no? Are you there? Yes, right, yes. You have taken an affidavit. What does this affidavit say? This affidavit will say, this affidavit is given by the attorney. Now, when it comes to a power of attorney, you know there are two people. There is one person called the principal. And there's another person called the attorney. Right? Principal is the person who gives the power of attorney. Say, if I'm the principal, if I'm going abroad, I would give certain powers to my attorney X. Right? My attorney X, I would give certain powers. Right? Now, when I go to the bank with the power of attorney, right? The bank would take an affidavit to the effect that the principal, it says, the attorney has to swear by his or her religion. By his religion, and say, I, so and so, of this address, of this, holding this particular NIC number, being a Buddhist, or perhaps being a Christian, or a Muslim, or a Hindu, or whatever the religion he is, and swear that he's the declarant, that's number one. Number two, that so and so, the principal has executed a power of attorney bearing number this, bearing data this, and perhaps maybe some other details of the lawyer who has done the power of attorney, appointing the attorney, appointing him as the attorney. That will be there, right? So the power of attorney details should correspond to the details in the affidavit. Then he will say, as number 3, he declared that the power of attorney is genuine and still in force, right? What would you say? genuine and still in force. This is the most important thing when it comes to an affidavit. Why do you think we need to get an affidavit saying that it is genuine and still in force? Any reason that you would know, or you would think of? Any reason? Why you say it should be genuine and still in force is the moment the principal is going to cancel the power of attorney, he should inform the attorney first, right? He would, by the affidavit, he would say that as to the best of his knowledge, he knows that this is a genuine power of attorney and it is still in force. That is, he still has the power to enter into transactions on behalf of the principal. Right? Is that clear? Is that clear to everyone? Any questions?
Yes.
Right. Okay. Now, how do you sign when it comes to a power of attorney? Right? So we are going back to the mode of execution. Right? So say A. Pereira. A. Pereira is the principal, right? And B. Pereira is the attorney, right? So you write A. Pereira by his attorney and B. Pereira places his signature, right? So similarly, when it comes to a partnership, right? The other partners' names, say the partner A, partner B. Partner A has given his powers to partner B, right? So you write A partner by his attorney and B signs on behalf of the attorney, right? Or else, if the partner is present in person, how would he sign? Just his signature. Yes, just his signature. But when he has a power of attorney of the other partners, he would sign as A. Pereira by his attorney and he would place his signature. This is the other partner's name and this is his signature, right? That is how it happens. Any questions on this? Any questions? Right. In partnerships, do you find an embossed seal or do you find a rubber seal?
Rubber seal.
Yes. In every partnership, there should only be a rubber seal, right? So it will say AB company partner, or AB, say perhaps say, oh, AB, they don't use the word company, no, so say AB and that they will say partner and the signature. AB Brothers, AB and Sons, That's how mostly the partnership companies go, right? And they would place their signature, right? Now, when it comes to typing of documents, you would see, as in the slide, it will go as A, that's the person's name, a particular partner, A, B Pereira of the particular address, and B Pereira of particular address, carrying on business in partnership. That's very important. You need to type in your, perhaps the loan agreements and other document, this in this way, at particular place, under the name, style, and firm of, right? That's how you would perhaps type when it comes to partnership documentation, right? Right. Any questions up to now on these two matters? Right. Right. We are moving on to companies, right? This is a very interesting area, companies. So what do you know about companies? What are the things that you know? I'm sure you're working with companies. Yes, there is a question here, Malindo. If it maybe, since though it is not related, I will take up your question now. The difference between affidavit, Malindo wants to know the difference between an affidavit and an indemnity. Affidavit and indemnity are two different concepts, right? Affidavit is something you swear by the knowledge that you have, right? Say, for example, this power of attorney, that the power of attorney is genuine and still in force, right? Affidavits could be sweared. Say you have perhaps two names. You've been from your childhood. You've been your actual name, the birth certificate name carries one name, and maybe from younger days there had been a nickname and it had been registered, and you've been known by that name also. Right? So in some documents your name goes as that, and in some documents your name goes as in the birth certificate. But there would be a time where an organization or a bank would want to know whether they are two people or one person, right? So you would swear that in your birth certificate, this is my name, my name has been written like this, but I've been using this name. Both the names refers to me, the same person, right? Affidavit is something that you declare by your knowledge, right? By your knowledge, and you swear it by your religion, right? And that is if you have declared or perhaps told something wrong or something false in an affidavit, there can be a lot of repercussions to you, right? It's a criminal liability, right? But when it comes to an indemnity, indemnity is where you say, if something goes wrong, I will look after you, right? We take indemnities from our customers, right? Maybe maybe the way when the customer has lost the FD receipt, the original FD receipt, we take an indemnity. In that indemnity, what we say is we get from the customer is that in the event someone comes and claims from the original, if something, I mean, if you are to, I mean, if something like when the original is lost, still you have to uplift the FD and give. But what we need to know is that if something goes wrong, customer needs to indemnify us. Customer needs to say, hey, look here, I will look after you. I will make sure that nothing is going to go wrong because of the fact that you have acted on my word, because the bank has acted on his word, on the customer's word that his affidavit is, sorry, his perhaps the FD receipt is lost, right? And you take the customer gives an indemnity to say, if something goes wrong, if someone else also comes and claims, I will indemnify you, right? So the affidavit and the indemnity are two different concepts, and the validity of both, or perhaps both are valid, I would say, not that they are invalid, but the gravity is more on an affidavit. Because you swear by your religion, and the affidavit, if it is a false information or something false that you have declared, that gives you a lot of liability than in an indemnity. Does that answer your question, Malindu? Right, okay. So we were talking about companies as a separate legal entity. What do you all know about companies? What do you all know about companies? Anything that you know about companies? I'm sure I could get at least one person out of 17 answering my question. Anything that you know about companies? What do you know about companies? Maybe, perhaps, what do you all know? Whether the types of companies or anything that you know about companies? I'm wondering that whether all of you all are still there in person behind your or electronic devices, or whether some of you all have fallen asleep, or whether you all don't know to answer this question. What is a company? What do you all know about it? Maybe it's not the perfect answer, it doesn't mind. I need to know what comes to your mind. What do you feel? What do you think a company is? Yes, Laksiri, thank you very much. It says maybe a private company, maybe a public company. Yes. So when it comes to a company, unlike in the earlier examples that we took, the sole proprietorship and yes, very good. It's a legal entity engaged in business. That's the exact word that I want to get from you all. Right. When it comes to a company, they say it is a legal entity. Right? Now, when it comes to the sole proprietorship and the partnership, the people were personally liable. The sole proprietor as well as the partners. They were personally liable. That means they were liable unlimitedly. They had an unlimited liability. But when it comes to companies, their liability is limited, right? Their liability is limited. Their liability is limited to the assets of the company, right? Not to who are the people who drive the company? Whom do you call them? Who are the people who drive the company?
Directors.
Yes. Their liability, unless in very um, uh, uh, unless in very say very limited circumstances, their liability would always confine to the assets of the company, right? There are instances where the liability of the directors would go beyond their duty, but that is in very limited circumstances. But in general, when it comes to companies, their liability is quite restricted. That's why they are called limited liability, right? Now, if you see here, you have the company. Here you have people called directors. Directors are the people who are driving this company, right? So you have another set of people in this company. What are they called? There are directors in the company.
Shareholders.
Yes, shareholders, right? Shareholders are people. Shareholders are people who would bring money into the company, right? They are the people who would bring money to the company. They would bring money to the company, and out of the shareholders, you can appoint one of the shareholders as a director, right? Or someone else from outside also can be a director, right? So basically, the directors steer the company, right? So every director need not be a shareholder of the company, right? And on the other hand, every shareholder can not necessarily be a director of the company, right? The shareholder can pump his money to the company and be as a shareholder as it is. Or in the alternative, being a shareholder, he can be a director as well, right? Or else you can bring someone totally outside into the company who is not a shareholder as a director to the company, right? So, is that clear to you all? Any questions?
Yeah.
Right, okay, right. Before we move on, so what are the characteristics of a company? What are the characteristics of a company? A company is always incorporated, right? It like the sole proprietorship, like the partnership, it has to be incorporated. But the mode of incorporation is very complex, right? How do you incorporate companies? Right? Incorporation of companies are dealt with have you all heard of this? ROC, Register of Companies. Can you all see the board? Yes or no? Yes, right, thank you. At the Register of Companies, companies can be incorporated. You know where this is? This is down DR Vijayawardena Mawatha, number 400. It's called the Samagam Medura. That is the place where companies are incorporated and all affairs of the company are being looked after by the Register of Companies in Sri Lanka. Why I told you the location is you need to know these things to advise your customers, right? This is down DR Vijayawardena Mawatha, right? So, Register of Companies is a place that incorporations and the company related matters are handled at. When it comes to incorporation, first a company needs to find, this is something extra, the company needs to find a suitable name, right? That has to go for approval at the Register of Companies. Mind you, we are lucky, these are now online, right? First, they have to select a particular name, right? Then the Register of Companies will approve the name. When it comes to selecting of a name, the name cannot be the exact name which is already registered. If ABC company has been registered, you also now can't go and take the ABC company name, right? And there are certain restrictions. You cannot use the word president in your company company name, or you cannot use perhaps so certain restrictions are there. President is one. You can't use the word president in companies, and certain restrictions are there. So once those restrictions are foregone and the company approves the company name, then you have to incorporate your company. For the incorporation, you will have to get, the customers will have to get assistance of a person called company secretary, right? The company secretary. So they will fill up the necessary forms, send it to the Register of Companies, and then incorporate the companies. Every company has something called the Articles of Association. Have you all heard of it?
Yes.
Yes. That is like the Bible of the company. It will say what the company has to do, what are the things, how the meetings are being conducted, how the shares are being transferred, how the directors are going to be dealt with. Those things are there in the articles, which we will come to in much more detail later, right? So companies, how do they sign? What do they have? They have something called what? Common. What do they have? Common. Yes. They have the common seal. Yes, they have the common seal, right? So when it comes to wrapping up what I have just told, characteristics of a company, it has to be incorporated, it is an artificial person, it has perpetual succession. When a company is born, when a company is incorporated, right? One set of people leaves and another set of people can come in, right? It has succession, right? And then it has, what else? One characteristic you all were talking about? One special characteristic. It has limited liability.
A separate entity?
Yes, it's a separate entity. It's an artificial person. It can transfer shares. We will come to the shares later. It has perpetual succession and it has limited liability. Right? Now, any questions up to there? Right. We are moving on to the companies that are recognized under the Companies Act. When was the new Companies Act came into force? The new one? Any idea? Yes, very good. Number 7 of 2007. Yes, good. So from 2007, we are having, it's not rather a new set. This was there, but certain names have been changed and but the liability is still the same, right? So as you can see in the slide, you have limited companies, you have, unlimited companies, you have offshore companies, overseas companies. So under the limited companies, you have the public ones, the private ones, the companies limited by shares, and the companies limited by guarantees. I'll just give you a brief introduction because we are going into them as we move on, right? So public companies are companies which are listed on the stock exchange. Private companies are the companies that we generally see in our day-to-day lives, right? Then we have offshore companies, which are companies which are incorporated outside Sri Lanka, which carries on business outside Sri Lanka, and overseas companies which are incorporated outside Sri Lanka and has a registered office in Sri Lanka, right? So we are going in detail to that. Right. What do you mean by listed company? Any idea? What do you mean by listed company?
A company called market.
Sorry, yes, company listed in the Colombo Stock Exchange.
Listed company.
Sorry? Yes, company listed in the Colombo Stock Exchange. So we said we have private companies, we have public companies, right? These public companies come under a broad category called limited companies. Basically, we have private companies, limited companies, and which are listed in the Colombo Stock Exchange come as public companies or PLCs, right? As PLCs. Private companies, I'm sure your retail banking sector would always come across these type of private companies, or some may have, still have private companies in the corporate sector as well. They're the most commonest form. Husband and wife get together, forms a company, right? And forms a company and starts on business. The importance of it, generally it is known as PVT, right? Limited, and the ones those are listed goes as PLC and the others go as limited, right? Or with the abbreviation LTD, right? So move on. Right. Limited company. A company that issues shares, the holders of which have the liability to contribute to the assets of the company, In any specified in the company's articles as attached into those shares, a limited company can be a public, private, or an offshore company that we discussed. Right. Then we have companies limited by shares, companies limited by guarantees. Companies limited by shares where the liability of a particular member is limited to the number of shares that they have taken in the company. And when it comes to companies limited by guarantee, the companies limited by guarantee, they don't issue shares at all, right? Each member of the company, they undertake to the extent they have contributed to the assets of the company in the event of a liquidation, right? So generally, when it comes to companies limited by guarantee, you would see companies like NGOs or charitable institutions mostly can come under the limited by guarantee category. There is one unique feature in these limited by guarantee companies. Can anyone tell me about that? Have you all come across these companies which are limited by guarantee? In most of the instances, these companies limited by guarantee do not carry the word limited. Right? Certainly NGOs, maybe certain charitable institutions, they do not carry the word limited, right? But they are incorporated as a company which is limited by guarantee. Right? Right. Private companies, we are coming to the most commonest form. Private companies, as I always told you, any questions up to now? Right. Maybe there are husband and wife who would incorporate a company, say AB Private Limited. A is a director, B is also a director. Shareholder, she is also a shareholder, right? So there are shares issued. You know what our shares are? Any idea what shares are? When shareholders pump in money, they need to have some sort of recognition for the money that they put, right? So in legal form, there is something which is called shares. Shares, right? The company needs to issue shares to the shareholders. Right? The company needs to issue shares to the shareholder. Right? And have you all heard of this word share certificate? Right? This is the document that a shareholder will get when he pumps in money. What will the share certificate have? Can anyone guess? What will the share certificate have? Any idea? When a shareholder pumps in money to the company, very simply, right? The company needs to issue shares to the shareholder, right? Now the company issues shares, no? So there should be something somewhere documented, no? That documentation is called a share certificate, right? What do you think that share certificate would consist? What are the things that should be there in that share certificate?
The price of a share, the number of shares that person has bought, and the total of it.
Exactly. The number of shares, the price of a share, right? And the amount that he has bought, all that is there, right? That's a share certificate, right? This share certificate is of value to the shareholder, right? This certificate is of value to the shareholder at a time he wants to sell his shares, right? Now remember, this is a private company. This is a private company. If the shareholder wants to sell his shares, he can't go to the public, not like trading in the Colombo Stock Exchange. He needs to find someone to buy his shares and move out, right? He needs to find someone to buy his shares and move out. The uniqueness in a private company is you cannot offer shares to the public. He has to find his own transaction to sell his shares, right? He has to find his own way to to sell his shares, right? So in a private company, as you can see in the slide, the maximum shareholders should be how much? How much? Maximum shareholders in a private company? 50. 50. In a private company, 50. The moment the shareholders increase, you cannot form a private company. Then you have to form what is called a what? What is called a limited company. Then you have to go for a limited company, right? Okay. 3 o'clock. You all want a break now, or shall we go on for another 15 minutes, or how do you want?
We'll move on, miss.
You all move on. Yes, right. Okay. Right. So as I told you, if there are more than 50, you will have to incorporate what is called a limited company, right? In your corporate banking, perhaps your career, you would have come across, right, companies, private companies, when they grow their business, right, they want to change their status of the company to a limited company. Have you all seen those instances? Have you all come across these instances? Sometimes Partnerships. Partnerships also can be the partnership business is now turned into a limited liability company. These things can happen, right? This is at the discretion of the partners or perhaps the directors. The transition can take place, right? Similarly, a company which is a limited company, right, can also once again go back and become a private company as well, right? Here I repeat, sole proprietorships, for that matter, sole proprietorships also. Sole proprietorships, when they are there for a long period of time, they can convert their businesses into partnerships, right? Partnerships, as time goes on, when they want to, because their liability is unlimited, no? They want to limit their liability. Perhaps all partners get together and now they want to form a private company. That is possible, right? Private companies, when they are there, they want to change their status because they are growing, right? They want to have more shareholders. Shareholders means a lot of money coming into the business, right? So they want to exceed the 50 limit, right? And they want to change their status into a limited company. Similarly, if you are a limited company, you can always change your status to a private company, right? Any questions on that? Any questions? No questions? Right. Now, these limited companies, as I told you, if they are listed in the Colombo Stock Exchange, they become public companies, right? They become PLCs. What is the uniqueness of a PLC? What is the uniqueness of a PLC? When it comes to shares, what is the uniqueness? What is unique to a PLC? When it comes to shares, anyone? When it comes to a PLC, the uniqueness is they have issued shares to the public, right? They have issued shares to the public. That is a unit. And their shares are being freely traded in the market, right? Their shares are being freely traded in the market. But with this, with becoming a public company, these companies have a lot of responsibilities towards whom? Towards whom? When they become public, to whom are they responsible for?
Shareholders.
Yes. They are responsible for their shareholders. And that is why Colombo Stock Exchange have put up a lot of rules for PLCs to adhere to, because this is public money, right? So that is why from the financials to setting up AGMs and accommodating virtual AGMs these days, that is why the Colombo Stock Exchange is looking after the PLCs, right? And you know, if they don't adhere to certain requirements which are imposed by the Colombo Stock Exchange, they have power to what? Delist the PLCs, right? They have powers to delist the PLCs. So that type of regulatory authority the Colombo Stock Exchange has in respect of PLCs. Does this restriction apply to private companies?
No.
Is the Colombo Stock Exchange going to regulate private companies? Yes or no?
No.
No, yes. They are not regulating private. It is only the PLCs. I asked you that question to see whether you all are awake, right? So only PLCs are being regulated by the Colombo Stock Exchange, right? So so we have these offshore companies. These type of companies are incorporated under a foreign company, foreign jurisdiction, right? Maybe in Germany or a European country or somewhere in the world, they are incorporated there, right? And they carry on business in Sri Lanka. And when it comes to offshore companies, there is a separate section under which these offshore companies are governed, right? So we have the unlimited companies, companies that issue shares to the shareholders, which have an unlimited liability to contribute to the asset of the company. Now, I want to bring this distinction out. Now, when you are a shareholder of a PLC, right, you have, now you know what is trading in the stock exchange. You have, say, 250,000 shares of John Kill's Holdings, right? You have 250,000 shares of JKH. Right? In case JKH is been liquidated or wound up, right? Your liability is only up to this amount. You will lose only this money, right? That's your liability is limited. But when it comes to unlimited companies, right, your liability is unlimited to the assets of the company. That is the difference between these two types of companies, right? Overseas companies are companies where a company incorporated outside Sri Lanka, but they want to have a business place established in Sri Lanka, right? Like, for example, the Citibank, it's an overseas company. Right? Generally, what happens in a company like that is a a power of attorney is given to the CEO or perhaps the managing director of the company to transact into business. That's how it happens, right? So when we move on, when it comes to private companies, these are just form numbers, articles of association, and you get the form number 1, form number 2, right? Then the list of directors, the registered address. I will take this matter now. What is the importance of articles of association? Can anyone tell me? Have you all seen the articles of association? All of you all, I'm sure, though all of you are silent now, I'm sure every one of you have gone through articles of association of companies, right? That is like the constitution of a company. What is a constitution? Constitution is the do's and the don'ts, the do's and the don'ts of a particular company, right? Like Sri Lanka has a constitution, right? The companies also have their own constitutions in several jurisdictions. In Sri Lanka, what we have now is the articles of the company, right? Now, under the previous regime, we had something else also. Can anyone tell me what it was? Under the previous Companies Act, we had something else. Sorry. What did we have previously? With the articles of association, we had the memorandum of association. Though it is in the past, I want to touch on that because you need to know something about it, right? Memorandum of association. Memorandum of association carried objects of the company, right? It said this A company is onto construction business, right? Is onto construction business, and it will put up houses, right? Buy real estate, right? These are the objects of the company, right? So basically, this when the memorandum of association was there, when there were objects of the company could not do anything beyond this. The company could not do anything beyond this, right? If they had done anything beyond this, right, it would be beyond the powers of the company, beyond the powers of the company. And you call that ultra vires. If the company had objects in the previous regime, under the memorandum of articles, the companies had objects of the company. That is, these are the things that companies should do. Anything that companies did beyond this, right, would be ultra vires. That means the company was not authorized to do certain things, right? They were only authorized to do construction and real estate. In those instances, if the companies had violated this rule, they were perhaps the third parties who were relying on them had a problem. Right? The third parties who were relying on them had a problem. So, with the introduction of the New Companies Act, they said you need not confine your businesses to anything. You can do anything under the sun, right? You can do anything under the sun, right? So, with the New Companies Act, there came this, the objects were removed, the memorandum of articles, memorandum of association was taken away, right? And we were only left with the articles of association. Articles of association basically said how the show would run, how the show would run, how, as I told you, how the shares would be dealt with, how the meetings would be held, how the perhaps the directors would be dealt with, everything was there. Now, when this went out, right, when you incorporated new companies after 2007, right, it was only the articles of association. But there are many companies, right, who were incorporated prior to 2007. Still, the companies incorporated prior to 2007, unless and until they they adopted the Articles of Association of Act number 2007, their constitution was still memorandum, the 1983 memorandum and the Articles of Association. Did you get my point? Unless the companies which incorporated before 2007 adopted the 2007 articles, their constitution consisted of memorandum and the articles both, right? When that happened, you need to see whether the objects of the company are still there, because though the memorandum of association is now not there, the context, the effect of it is now deemed to have been incorporated in the Articles of Association. Unless the companies bring in a new set of articles under the 2007 Act, these is still valid, right? So you have to see whether your companies are still going under the old articles or whether they have incorporated or perhaps adopted the 2007 articles, right? That is very important. Did you all get my point? Any questions on that? Right, okay. Thank you. So you need to ensure that if you have old articles, old memorandums in your files, please call your company and ask them to provide the new set of articles of association which have been adopted. If you all have not done so far, the fact that they have registered or perhaps re-registered under the New Companies Act does not matter at all. That is no bearing on this. They need to adopt the new articles and you need to have them in your file, right? That is very, very important. Please, if you all have not addressed that, or when an issue is coming up, if you happen to look at the constitution of the companies, the articles of the companies, if you see they are old, please ask the companies to provide you with the new set of documents. And if they say they have not adopted, the old one is still valid, please go through them carefully, right? because there is a difference between the old articles and the new articles. So you need to be very cautious of this matter, right? Any questions on this? Any questions on this? Right. Then when you, we will move on to the certificate of incorporation, what it is all about, right? When a company is incorporated, the registrar of companies will give the company a certificate. This is just like your birth certificate, right? It will give the certificate. It will give the certificate. It will give the certificate, and that is called the certificate of incorporation. That is just like the birth certificate of your company, right? Now, if you happen to, when we go through the slides, each type of companies have a separate form number to separate types of companies, right? Say, for example, we talked about private companies. Private companies would have a separate number. Limited companies would have a separate number. Overseas companies would have a separate number, right? So basically, what you need to know is, if you could memorize a number of the certificate, it's quite all right, but it need not necessarily do it. If you read the incorporation certificate very carefully, you will find out what type of incorporation does the incorporation certificate would carry, right? It's very important when you see legal documents, right? Maybe a incorporation certificate or a form or whatever it is, don't think that you don't know. There is nothing that you don't know. It's very precise, simple language that is there, right? Read them. Read not from a certain point. Read from the beginning itself, from the topmost corner. Read Sri Lanka Prajatantra Samajawadi Janrajya කියලා පටන් ගන්න තැන ඉඳලම එතන ඉඳලම කියවන්න. You read it, the Sinhala, if you have the proficiency in Tamil and English, read it, then you will understand what type of a incorporation or what type of a document that the customer has brought to you, right? So that is the certificate of incorporation. It's important now when the customer comes to you with the certificate of incorporation, do you accept the photocopy, or how would you accept? What is the method of accepting it? Would you just accept a photocopy or what?
Certified true copy.
Yeah, certified by whom?
Secretary of the company secretary.
Yes. You should get it certified by the company secretaries, right? Now, when it comes to signing by the company secretaries, you know who a company secretary is. Company secretary is an officer, rather. An officer of a company. A company cannot run without a company secretary. You have the directors. You need to have the company secretary to do the ROC work, to take down minutes, right? And to do all the filing of the company, to take business decisions when it comes to synchronizing with the Companies Act and the businesses, the company secretary's role is more than taking minutes of a company and filing documents of the register of companies, right? That you need to understand. Why I say this is, a company secretary, they say, can make a company or destroy a company, right? So you need to see whether the company secretary has signed the documents. Company secretary can have, secretary can be an individual person, right? A person, say ABC Pereira, who is qualified to be a company secretary, can be a company secretary, right? Or a firm, a firm which is incorporated, right? Maybe DLNFD Serums, they can be company secretaries. Or ABC Private Limited, Business Solutions Private Limited, they can be an incorporated company as well, right? So always when the company secretary signs the document, see whether it is the correct person, whether it's a correct company, the present company secretary has signed the documents, right? When it comes to, say, latest documents, right? So here you get the incorporation certificate signed by the company secretary, right? Then here we have the list of directors. Form number what? What is the form number? Yeah. Yeah. Thank you, Taruka. Form number is form number 20, right? Form number 20 is important. Why? Not because only it carries the list of latest directors. Sometimes you must be corresponding with one director, right? But you may not know that director has left the company, right? So it is important, especially if you are going to give a loan, you get the latest form 20, right? Say last year you got a form 20, right? And this year also you get a form 20, right? And the company says it is the same form 20. What does this mean? It means that no director has changed, right? If it is last year also, it is the same company form. It is the same form that you have been provided this time also. That means no company, no director, no secretary has changed, right? When it comes to Form 20, I know you would not accept the photocopy. What would you accept? Who seal? What is the type of, how would you all accept the Form 20? And whose signature that you would rather accept the Form 20? A photocopy? Would you accept just a photocopy? Or of course you would want a certification? Whose certification would you want? Yes, the company registrar's seal should be there, right? If you can take that, it is the best, right? Why I say this? When the Form 20 is filed at the Register of Companies, the Register of Companies do file this Form 20 in their registers, right? And from that, because they don't issue certified copies if there are any problems, any conflicts, they would not issue, right? So it is important that you get the Form 20, a copy of the certified copy issued by the registrar of companies. Right? It should be issued by the registrar of companies, right? When it comes to the registered address, what is the registered address number? When it comes to private companies, what is the form number when it comes to registered address?
13.
Yes. Form number 13 is the registered address of the company, right? In some instances, in very rare instances, you will still get, when it comes to the confirmation on the registered address, you will get a form called the Form 40 under the previous Companies Act, right? If they give that, don't demand for the number 13, form number 13, because it simply says that the company's registered address has not changed since then, right? The company's registered address has not changed. What is the importance of the registered address of the company? Can anyone tell me? What is the importance? Why do we take, it's just an address of the company, it's there in the letterhead, it's there in the company's correspondence. Why do you still want to know it? Why do you still want to know the registered address as specified in the form? Is there any particular reason? Is there a particular reason why you want to know the registered address of the company? Any guesses? Any answers? The registered address is the address where you serve notices, right? Where you serve notices, that is the address. If the bank wants to serve a letter of demand, right? If it is being served at the registered address of the company, it is as if you have duly served the letter of demand to the company, right? If something is left or posted to the registered address of the company, it is seen that sufficient notice to the company is given. That is why the registered address of the company is very important. And that is why we request the customer to tell us, to inform us when the address has been changed, right? Keep in mind, that is why we request for the registered address of the company, right? So we'll take a break, maybe a 15 minutes break, and we will resume. Now it's 3:35, and we will resume after 15 minutes. Any questions up to now? No questions? Right. Okay. We will have a short break and resume in 15 minutes time. Thank you. We are back. Is everyone ready to listen to the next half? Ready? Yes, good. Right. We were on registered address, private companies. We took those also into consideration when we were talking about private companies. Right. We're moving on to public companies, the listed and the unlisted. Once again, every company, as you know, has its articles of association. So you will have to take those. Then the application form would be form 1, certificate of incorporation 2C, list of directors, so forth and so on, right? So these are just numbers. Just keep them for reference when necessary. Companies limited by guarantee, we discussed. As I told you, basically they are, the features are that they are mainly the NGOs or the charitable institutes, and that in most of the times they would not have the word guarantee, sorry, the word limited in their company names. If you happen to see rather the certificate of incorporation of a company limited by guarantee, if you come across, please read them, because it is not only the certificate of incorporation that comes with it. There is another certificate also which accompanies it, right? What it says is, at the request of the company registrar can allow the company to not to use the word limited. That is, without the word limited, the companies can register their names. This is only in respect of companies limited by guarantee, right? This is only in respect of companies limited by guarantee. The company registrar will issue a certificate to the effect that, apart from the incorporation certificate, that he empowers the company to use the company name without the word limited, right? So that is the unique feature when it comes to the companies limited by guarantee. Same as in the other types of companies, the list of directors and the registered address both carry the same form, right? Offshore companies, once again, the incorporation certificate form number is different, so that it will indicate that it is an offshore company, right? And you have the registered address, list of directors and the registered address, right? Sorry. Overseas company also, they have the certified memorandum articles of the association of the mother companies. As I told you, overseas companies are companies which are incorporated in some other jurisdiction but registered in Sri Lanka. Now, there is a distinction between incorporation and registration, right? Incorporate means that company is born, or rather incorporated in a particular place, maybe overseas, right? That is incorporation, right? Anything which is incorporated outside Sri Lanka can be registered. You have to know the difference between the two words, incorporation and registration, right? Those companies which are incorporated in foreign jurisdictions, foreign countries, can be registered in Sri Lanka, right? So that is the difference that it takes. Right. Then you have the list of directors, form number, the registered address, form number, so forth and so on. Incorporation company forms, certificate, registrations. These are just numbers that you need to understand. Right. Other forms required by the bankers. For what is form number 1? Form number 1, these are we are discussing about the form numbers that the Register of Companies is issuing, right? For you all to be a little familiarized with those, right? Form number 1. Form number 1 is in an instance where when the 2000 Act came into effect, all companies which were registered under the previous Companies Act had to be re-registered, right? So at that time, they had to register Form 40, right? Here, Form 40, they had to register. But with the incorporation of the new Companies Act, the application for the registration of the company, the form number is number 1, right? Now, there are 2 forms which I need to elaborate a little more on this. I'm sure you know about these things. Can all of you all hear me? Are you all there? Yes, right. Thank you. You all are there. Right. So, we are talking about form number 12, right? Form number 12 and form number 10, right? Form number 10 is where you file what is called a charge, right? What is a charge? Who can file a charge, right? Companies have assets, right? What are the assets they have? They have land and building, right? They have stocks. What else do they have? What are the other assets they have? What are the other assets the company has? They have land and building, they have stocks. What else? Vehicles, machinery, yes, they have, right? So when we take a mortgage over the assets of the company, right, we are required, this is from the banker's perspective, we are required to file a form called Form 10, right? What do we do by filing the Form 10? We say that we, X Bank, has created a charge over the stocks of the company, right? Why do we say this? We say this because at a time of liquidation or at a time of winding up, we become what is called a secured creditor. When we file this, when the bank files this, only we become a secured creditor, right? If we do not file, we become an unsecured creditor. What is the importance of this? When the company is liquidated, right? Naturally, the company will not have lot of money. They will have a limited resources. In this limited amount of assets, right, we need to make sure that our portion can be set off, right? So there is something called the ranking of claims. When a company is liquidated, first the EPF and the ETF of the employees are being paid, right? First the EPF, ETF, and then thereafter comes the secured creditor in the top list, right? If you are an unsecured creditor, you're last in the list, right? Perhaps when all these are paid, maybe your funds are over and you will not be left with anything. This is only at a winding up or a liquidation, right? So filing Form 10 is important, right? Not at the time of a recovery. Moreover, it is important at the time of a liquidation or a winding up, right? It is important at a liquidation or a winding up, right? So what does the Form 10 say? Have you all seen your Form 10s? Have you all gone through your Form 10s? It is a one-page document, right, where you type the company's name. Remember, tell your secretaries, tell your people who are typing the Form 10 to type it without any errors. No tipex, no erasures, nothing, right? And if it is P.N.D private limited, this dot has to be there. Very recently, I have found that ROC is keeping on rejecting Form 10s for not having the dot, right? So you have to type the company name exactly the way it is written in the incorporation certificate, right? Then you have on which you have created the charge on, maybe the mortgage bond or maybe the stock mortgage bond, right? So you have to give the particulars, the details of the instrument which you are charging at, right? You have to give the mortgage bond details. If it is a stock bond, the stock bond details you have to give them, right? So there are some other forms you have to give the amount, right? The amount, and here you get a column, right? For the signature of the director and the secretary, or either the two directors, right? So make sure the signatures are within this box. Otherwise, they are going to reject it. Very recently, I got to know that Register of Companies are accepting Form 10 online, right? Just check with your credit admins and see if that can be forwarded online. Please do so, because what is the time period for filing a Form 10? What is the time period? We have 14 days. What else? Yes, Akila, you're correct. It is 21 working days that you have to file, right? That is 21 working days is like this. The customer comes, he signs, you put it in the drawer, not from the day that you find your document once again. It is from the date it has been dated, okay? If it has been dated on the 1st of, say, 15th of August 2020, within 21 days from this date, right? Within 21 days from this date, you have to send it to the land registry. If you are in Colombo, it is always best that you hand deliver it and have a mechanism to hand deliver and get the receipts properly filed, right? And if you are outstation, if you're posting these documents, make sure that you have the original registered postal article properly filed in your files, right? They are very important, right? Register of Companies number 400, Samagam Madura, Colombo 10. Right? That's how their address goes. You can always Google up on the net, Google up and see. It's there. But what is, it's at the Register of Companies. It should go to the Register of Companies, right? That is important. Who else can sign this document? The directors can sign, the director and the secretary can sign. Who else can sign?
An attorney at law.
Yes, an attorney at law also can sign this document stating that the company has created a charge, right? Stating that the company has created a charge. Now, once this goes to the Register of Companies, if you are lucky, you will get the Form 12. Generally, we hardly get the Form 12, right? But in some instances, you get the Form 12. What is Form 12 is, for what you file at the registry, you are given a charge certificate, right? It's kind of a certificate saying that under this mortgage bond, there is a charge in respect of this company. That also, please do not put them in your drawers. Please file them in the relevant security file, because you may have sent it, right? and it is very difficult to trace if there are no records. I don't say you can't trace, you can trace, but you have to go to the register of companies, send some clerk there, sit there and do the searching, right? And you have to, each form 10 record for mortgage or assets here. You need to pay for each certificate, for each form that you have from the land registry. If you don't have the receipts properly filed as a certification, if you have still not received the form 10, for the fact that you have filed form 10, you can get a certified copy of the form 10 from the from the register of companies, right? You can take that. But per form, you have to pay 1,000 rupees, right? You have to pay 1,000 rupees. So I think for a facility, for a customer does not, corporate customers keep on taking facilities. So the moment you file the form 10, always make sure that you have a copy of this particular document as well as the receipt, right? Here is a question: is form 10 require only for mortgage over assets? No, it is not only for mortgage over assets, right? Form 10 has to be filed even if you're taking a fixed deposit of the company, right? If you're taking a fixed deposit of the company, in your banks, you will have a document called the charge document, right? You create a charge. There is perhaps a 1 or 2 page document saying that you create a charge over the particular asset, because fixed deposit is also an asset of the company, no? So with that, separately, when you give a facility over a fixed deposit, you will separately take a set off as well. That's different. But for the purposes of the register of companies, you will take a charge document, right? You take a charge document, and in that document, there will be particulars of your fixed deposit and so forth. And it is drafted in such manner that is the document that you are creating a charge on. Now, when you're creating a charge over a mortgage bond, you put the particulars of the mortgage bond. No? Likewise, if you are making a charge over a fixed deposit of a company, that is the charge document, is the document on which you are claiming the Form 10 rights, right? So you have to annex the certified copy of that particular document, fill the Form 10, right? And you have to pay 8,100 rupees. From now, what is the amount? Yeah, 8,100 including VAT, right? Including VAT, you have to pay. You have to send a pay order for that, right? And get your acknowledgement done. Unsecured facility, when it's clean means you don't take a asset of the company. When there is no asset, there is nothing that you can create a charge on, right? If you take an asset of the company only, this Form 10 have to come into effect. Tell me, have you all when it comes to savings build up, what is the situation? Do you all file Form 10 or do you don't? Savings build up. Do you all file Form 10 or not? Savings build up? When you all take savings build up as a security? Okay, some say they don't. But when it comes to a savings build-up also, you need to file Form 10, right? There is a special charge document. You can ask, perhaps we do. We have a special charge document done, and we do file it at the register of companies because that's also a charge. That's the asset of a company. So you need to file Form 10. Any questions on that? Any questions? So basically, if you are looking up at a cash build-up, right, for a savings account or savings account, you need to file Form 10, right? So the Form 10, as I told you, you have to fill the Form 10, have the particular mortgage bond or the charge document annexed, right? Generally, a certified copy has to be annexed along with the pay order with a covering memo. You have to send it to the register of companies within the time frame, right? Now, tell me, if it is not filed within the time frame, what is the recourse that you would have? If you don't file within the stipulated time period, then, especially when it comes to notarially executed documents like the mortgage bonds, when we execute, and very rarely if we forget to file the Form 10, then we have to go to court. We have to go to court and tell our reasons as to why we couldn't file the Form 10 within the stipulated time period, and ask permission from court, right, to direct the Register of Companies to register our Form 10. And if the court allows us, and if the court directs the Register of Companies, then only the Register of Companies can file the Form 10. Yes. Yes, there is a point there, but set off document is where you when the facility is in default. You can exercise your right over a set of document. You can exercise your right which the customer gives you over a set of document when the facility is not paid, right? For example, if the facility is going on, but the company is at a liquidation situation, then still your ranking of claims will come into effect and you would have a cover, right? Did that answer your question, Nimali? Right, okay, thank you. Right, any questions over Form 10? Any questions? We will move on. So the Form 12, Form 10 receipts, Form 12 certificate, please keep them in your relevant security files, not in your drawers. And sometimes you may not get the Form 12 at all. but it's always best to follow up and get the Form 12 for completeness purposes. But if you have proof to show that you have filed the Form 10, still you have a chance of perhaps it's valid as, I mean, it shows that you have created a charge, right? So essentially, if you had not got Form 12, you need not worry much, but it's best to have the Form 12, but you have to have evidence as to the Form 10 with you, right? So these are the new incorporation companies. We talked about the Form 13, we talked about the Form 20. Form 30 is at a time of liquidation, the unsecured creditors. Now, if you have not filed your Form 10, then you become an unsecured creditor, and at a time of liquidation for your proceeds, you will have to file the Form 30. But if you are a secured creditor, you will have to file the Form 31. Now, these forms in this era, we all banks are not in a good footing these days, no? So please be mindful of these instances where if companies go into liquidation, you need to file your claim by these forms, right? So this is regarding the re-registration of all old companies. By now, almost all the companies, most of the companies rather have re-registered. But if they are not re-registered, what would be the position? If they are not re-registered, what would be the position? Anyone knows? The companies would be struck off from the registered list, right? The companies would be struck off and their assets would vest on the state, right? And their assets would vest on the state. I will share with you an experience that was shared with us by a lawyer in this re-registration process, right? There was this company, ABC Private Limited, which had a property in its name, which was incorporated under the previous Companies Act, right? And it had not re-registered itself, right? They have incorporated a company under the previous Companies Act. They had a property, so the deed was written under the name of ABC Private Limited, right? But after the new Companies Act came into effect, they did not re-register the company, right? When the case was like that, now this particular company wanted to sell this particular property, right? When they want to sell this particular property, only they knew that they had to re-register the company, because these directors were foreigners. Perhaps one had died, and who was in Sri Lanka had died. So this particular foreigner was not aware of this re-registration process, right? So basically, what happens is, when you don't re-register and your name is struck off from the registrar of companies name list, your assets will be vested in the state. ඒවා ඔක්කොම රාජ්‍ය සන්තක වෙනවා. ඔක්කොම දේපල රාජ්‍ය සන්තක වෙනවා. Right? Now, basically, this particular company's assets are now vested in the state. One fine, perhaps, I don't know, a lawyer or some person had given him a bright advice as to incorporate a new company under the same name. Now, since it is struck off, it is no more there. No? So he has gone and incorporated a company under the same name, right? And he got the registration certificate under the same name which appeared on the deed, ABC Private Limited. So here you have a certificate, here you have a deed which has the same name, right? But this was a new company and the company number is different, right? This particular lawyer who was to do the transaction, who was to act for the prospective purchaser, identified this defect, right? The fact that he had incorporated a new company for which this asset did not belong to, right? Because it was vested in the state. So this lawyer said, I can't do the transaction, right? But later on, they had found that this company had sold the property and they had not, perhaps the people who did the transaction wouldn't have taken into consideration the date of incorporation and the PVA, the company registration numbers, and I don't know what the plight would be of the actual purchaser right now. But in actual fact, when it comes to law, that particular property is now virtually vested in the state, right? So these are very rare situations, but these are things which could happen, right? So that is how Sri Lankan people would do, would circumvent the law and go ahead, right? So moving on. So we spoke about this memorandum of association, about the principal objects, and we also told that the memorandum of our association would be part of the articles of association of the company, and the articles of the existing company also will continue to be the articles of the company if they have not adopted the 2007 articles, if they have not adopted the 2007 articles, right? So charge. We talked about a charge. We talked, there are two types of charges, right? Fixed and floating charges. Fixed charges are where generally fixed charges are taken when it comes to land and building, right? Floating charges are generally where you have shares or perhaps cash or something of that. But in any case, a charge, the banks can create a charge over the company's either the fixed assets or the floating assets, right? Right. Now, companies, how do they execute documentation? So as you know, the company is a legal entity. There are directors, right? Company cannot do anything of its own. The directors drive the company, right? How do directors take decisions? What is the method? Company takes decisions. What is the method? What is the method that a company could arrive decisions at? Yes, thank you. Board meetings. What is a board meeting? Board meeting is the board, that is the directors, get together and discuss on certain issues and arrive at a consensus, right? They arrive at a decision as to whether to proceed or not to proceed, right? Board meetings can be made physically, like A, B, and C can sit around a table, right? With the company secretary seated, they can arrive at decisions, right? The constitution of the company provides that to call for a board meeting, right, they will have a stipulated time period, the notice period that they should be given, right? That should be mentioned in the articles. They should be given sufficient notice, right? The place where they would be meeting. Once the notice is given, the directors come and discuss. There should be an agenda, right? Generally, as you would always know, in private companies, they never have their board meetings, but the minute is there, passing resolutions that that the company has resolved to take a short-term loan, isn't it? Right. Perhaps they are not in their minute books, right? But it's still there. But actually, what should happen is the board of directors should sit together along with the secretary. The decisions that the directors are being taken has to be minuted, and the secretary has to prepare the minutes, and minutes have to be recorded in the minute book. That is the correct way of doing that. Directors sit, secretary, take minutes, minutes were recorded in the minute book. From the minute book only, you are expected to issue extracts to third parties, right? You need to maintain your minute book. Now, is it only physical meetings can be conducted? Is it only physical meetings that could be conducted? No. Right, Hasalaka. Thank you. What are the other methods of conducting meetings? Say a director is abroad. Then how do you conduct a meeting? There are 5 directors. 4 of them are abroad, different countries. How do you conduct a meeting? What is the method of conducting a meeting? You can conduct a meeting, you can arrive at a decision by circulation. It is called a circular meeting. Right? It is a circular meeting. How do you conduct a circular meeting? The company secretary has to prepare what they have to resolve. Say that the company needs to resolve that they are taking a loan from your bank, right? She will prepare a circular resolution, right? And write the directors' names here. This either can be faxed or emailed or whatever the source, but the rule is every director has to sign, right? When all directors sign, it will be a resolution passed by circulation, right? Yes, Himali. There would also be virtual meetings. Like we are teaching online, there can be virtual board meetings as well. And these days, it is very common, right? So I believe virtual meetings will continue in the corporate world, and it will be part and parcel of the way board meetings are conducted, right? So virtual meetings, meetings by circulation, and physical meetings are the ways that you could conduct a board meeting, right? Once the board makes a decision, it has to be minuted, and a board resolution is provided to you all. Now, tell me, in a board resolution, who are the signatories? Who are the signatories in a board resolution? Or whose signature would you all accept? Whose signature would you all accept? I'm sure you all would have got board resolutions in your day-to-day matters as per the articles. Okay, right. What else? Authorized signatories of the company and the secretary. Chairman with the secretary. Right. Good. Now, I told you that minutes of the meeting has to be in the minute book. It has to be recorded in the minute book, right? And it is an extract of this will be provided to the bank, right? With whom is this minute book? It is with the secretary ideally, right? So when this is issued, you can get the chairman's signature along with the company secretary, right? Or else you can get 2 directors. With 2 directors' signature, you can get, or in the alternative, because the minute book is with the company secretaries, even if it is issued by the company secretary, still you can accept. Still you can accept, right? This may be slightly different from the rules and regulations that each bank has. But what I tell you is a general practice, right? What I tell you is a general practice which is acceptable, right? Which is acceptable. Or, as Kasun said, in your in the articles, there is a section for what is called this authentication of documents, right? There is a section for authentication of documents, right? Go through that. That will tell you from whom the document should come from, right? So those are the methods as to how a certified extract should receive. With those 2 signatures, if it comes in a A4 sheet, do you accept? A4, just a A4 sheet? Do you all accept? No. It needs to be on a what? Letter head. Yes. It needs to be on a letterhead, right? You have to be very mindful of these things, because if something goes wrong, if some forgery takes place, and you look back from the board resolution, the forged documents have been prepared, right? We have come across these things. Okay, that is for the board resolution. And so when it comes to companies, we talked about wait, before we come to the typing, I need to talk to you about the execution of documents, right? Now, who should sign the documents? Say maybe your loan agreements, your short-term, perhaps banking documents. How do you all tell me? How do you all get the signatures? Okay, as per the board resolution. Any other way? Do you all strictly stick to the board resolution, or how does it happen? It's like this. Now, in some articles, right, they do have a provision for the seal of the company, right? All directors has to sign. Let's see. There is in some articles, there is a provision for the company seal, right? It says the company seal shall be affixed in the presence of director, secretary, or 2 directors of the secretary, or 2 directors of the company, or any other person authorized by the company, right? If they say that, you can very well take a director or or two directors or a director and a company secretary, right? And for that matter, there is a position called alternate director. Have you all heard of the word alternate director? Alternate director is where when a director is overseas or he cannot come and perform, in his position, the company can appoint another director on his behalf, right? He is not a new director. He is doing what that director ought to have been doing, right? He is an alternative person to that particular director. So you have to file particular forms at the Register of Companies and get the alternative director appointed, right? Once the alternative director is appointed, that alternative director also can sign. They fit into the director's position. He is as good as the director, right? So the alternative director also can, along with the other director, sign on behalf of the company, right? That is, he can witness the company seal, right? Now I said some articles, they do have two directors, director or secretary or any other authorized person, right? When you say any other authorized person, the company needs to appoint by a board resolution a person to sign particular documents on behalf of the company. But it is important that you see how it is worded. It can be worded to the effect that the authorized person can sign along with the director, right? Or the authorized person can sign on behalf of the company without a director. Basically, solely if this authorized person signs, that's it. It's as valid as it is. So it is very important when an authorized person has been appointed by the company, you need to read the board resolution very carefully and find out whether he's authorized to sign alone or whether he's authorized to sign along with another director. Right? Did you get my point? Did you get my point? Right. Okay. If you don't get my point, say type no, then I'll explain it again. Right? So you need to find out you need to find out how it has been worded. I have experiences where in some articles they don't provide for the signature of an authorized person. But in most of the articles, you will find that, right? Don't go by that norm. Always go back to the articles and read them, because I came across a company's article that it only said 2 directors of the company or a director and a secretary could sign. No authorized representative was allowed to sign, right? So you have to be, and in fact, the board resolution itself authorized a person to sign. We actually then we questioned the company secretary as to how they could do such a thing, and we pointed out that fact to the company secretary as well. So we had to do the documentation again, but that was a different matter. But the company secretaries also didn't know what was there in the articles. That was a different matter. But at one point, we also would be unsafe, because if we had not taken the proper signatures, our documents would be questioned. Our documents could be questioned in court, right? So you have to be very careful when it comes to who can witness the embossed seal, right? But after the 2007 Act, in most of the companies, they don't have provisions for the company seal, right? Perhaps company seal is not rather a compulsory document, a compulsory instrument under the new Companies Act, right? But if the company had been using the embossed seal during the old regime, I would always advise you to take a board resolution from the company. If they are not using it now, you need to get a board resolution to that effect from the company. I'll repeat it. If the company has been using the company embossed seal under the previous act and is not using it now, right? It is always advisable for you to have a board resolution in your file saying that the company is no longer using the embossed seal, right? Keep that board resolution in your file. Understood? Is it clear? Right. So when the company's articles are silent on the companies as to who should sign documents, it is always best that you get the names of the directors and or the secretaries' names, or if the names can be mentioned in the board resolution, it's ideal, or else at least who could sign on behalf of the company. Those details you should mention, you should ask the company to mention in your board resolution, especially when you're giving facilities, right? It's just 1 line or 2 lines that the company has to add, right? Always with the resolution of resolving to take the facility, request the company to say who and who will be signing on behalf of the company, right? If they can't give the names, at least the capacity, the directors, 2 directors or director or secretary or whatever it is, right? Now, apart from this, under the new Companies Act, there is another method of entering into contracts. Does anyone know about this? Have you all come across? Other than for this, there is a way of entering into contracts. Any idea? Any idea as to how the companies would enter into contracts rather than two directors signing, director or secretary or any other authorized person signing by a board resolution? The new Companies Act, right, gave provision to this. They gave provision to the power of attorney concept, right? Now, here you should not mix up. A director cannot give a power of attorney to another director to act as a director, right? I'll repeat it. A director cannot give a power of attorney to another director to act as a director, right? Generally, partners can do that, right? In a partnership company, partners do that because they are personally liable on certain things, right? But when it comes to a company, directors are just steering the company. So directors cannot give power of attorneys to another director to act in the capacity of a director, right? He can give power of attorney to another director to do his personal businesses, but he cannot give a power of attorney to another director to act in the capacity of a director, right? It is not that power of attorney that we are talking of here, right? What we are talking of here is the company as a whole. The company as a whole gives a power of attorney to a person, right? The company as a whole gives the power of attorney to a person to transact on certain instances. I have seen this type of power of attorneys in real estate business, right? There are lots of agreement to sales which are coming into effect. So at all the time, the directors cannot be running around to sign the perhaps the sales agreements. So what the company has done is the company has passed a board resolution, right? The company has passed a board resolution as per the articles, right? Mind you, this has to be provided in the articles, right? It says subject to the articles of the company. That's how the section goes, right? Subject to the articles of your company, right? They pass a board resolution that we will be appointing so and so, maybe the general manager sales, for example, general manager sales for as the attorney of the company for the purposes of, and here it will go enter into sales agreement, execute addendum to the sales agreement, enter into tripartite agreements, blah, 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 it will come, right? Now, that is the document which the board decides to appoint an attorney. But that document is not enough. Board resolution is not enough. You need to go one step further, and the company needs to execute what is called a what? Can anyone tell me? What does the company need to execute? All of y'all know this. What does the company need to go and sign, or what does the company need to do to give powers to an attorney? Execute what? Sign what? Any answers? What does a company needs to sign? Hmm? What does the company needs to sign? Are y'all there? Y'all are there? The company needs to sign what is called a power of attorney, right? The company needs to sign what is called the power of attorney, just like the power of attorneys that a normal person would give to another, right? And with that document only, the attorney could sign on behalf of the company over the powers that he has been vested with. Did you all understand? You need to have a board. First, your articles need to provide for such authorization. 2, the board needs to resolve. 3, the power of attorney has to be signed, right? With that, that particular authorized person can sign on behalf of the company. Understood? Is it clear? Do you want me to explain it again? Is it clear? Are you all there? Yes, right. Okay. Thank you. So, so that is how you would enter into how companies would enter into contracts, right? So when you type in the loan agreements or the other documents, this is how you should type. Say AB Private Limited, a company duly incorporated under the Companies Act of number 17 of 1982 and re-registered under number 7 of 2007. Now, if it is a new company, you can straight away go to and say a company duly incorporated under section 2 and number 7 of 2007, bearing registration number. You have to be very mindful of the registration number because private companies have PV numbers, public companies have PB numbers, and limited by guarantee companies have different numbers. What is the type of number abbreviation that is there for PLCs? Anyone knows? Private companies have PV numbers. Limited companies have PB numbers. Public quoted companies? Very good. PQ numbers they have. So the moment you see the number, you should be able to identify the type of incorporation that is there, right? And then you have to type where the registered address is at, right? This is the correct way that how you type these documents, right? So we are moving on to company name and number, right? Company name, as I told you, first you have to get a unique name for your company. And once the incorporation certificate is issued, you will be given a separate number. And under the New Companies Act, it is mandatory that you have these numbers, the company number, in all business letters of your company, right? Especially when a customer comes and opens an account with you for the first time, right? When the company sets the board resolution or whatever the document, you can be mindful of these things, right? Whether the company would have the company number in the business letters, right? Whether it has the company number in the company seal, right? Whatever the public notifications that the company makes, it should carry the company number, right? The invoices, receipts, it should carry the company name and the company number, right? So it is a requirement under the Companies Act, right? It is a requirement under the Companies Act that the name of the company and the number of the company is printed in their business correspondence, the company seal, and etc. Right? So we spoke about the company seal, right? Yeah, we talked in length about the company seal, and the ultravirus and the other, perhaps the slides I will take next week, and I have given you 20 minutes for any questions and answers that you would like to raise. This is your time to talk to me. Any questions from this, perhaps the 4 hours that we had, or any questions that you would like to clear up in the legal form? Let me know. In relation to your day-to-day activities. You can type if you feel shy to talk over the microphone, or you can always you can type to me, or you can raise your you can unmute the mic and talk to me.
Hello.
Yes.
Small thing is, let's say if you are receiving a board resolution on
Sorry.
a company secretary, if you are receiving a board resolution
Yes.
on a company secretary letterhead
Yeah.
signed by one director, is it
Director of who?
director
Director of the company or director of the company secretarial firm?
director of that particular company?
Company.
Yeah, is it acceptable, BR madam?
I don't see anything not to accept it, because it's on the company company secretary's letterhead and signed by a director. I don't see anything, but ideally, if the director is signing, ideally it should be on the company letterhead itself. But if when it comes on the company secretary's letterhead signed by the director, there is no particular reason for us to reject it. But for better measure, you can always ask the company to get it in the company's letterhead. But I cannot say that it can be rejected as such. Any other questions?
Excuse me, miss.
Yeah.
Is there a difference between some board resolutions are presented with the certified extracts as the heading, and some are presented with the resolution passed by the board of directors?
Yeah.
So, is there a difference in that? Because if
No.
it's no.
Yeah, go ahead.
No, if it's a certified copy, should it be signed by the secretary? Compulsory, mandatory, the secretary sign. If it's resolution passed by the board of directors, only the directors are sufficient.
Yes. It's like this. Whether it's a certified copy signed by the directors or whether it's a certified copy signed by the company secretary, there is no major difference in the board resolution where it will go to court and be challenged. It doesn't go for that extent. The mere wording that it is what you mean to say is certified extract of a board of resolution passed by the board of directors of blah blah blah, and it goes and the company secretary signs. So what you mean is, if it is say certified extract of a board of resolution, it is only the company secretary who has to sign it, not the directors. Is that what you are saying? Is that the point that you want to make?
Yeah, if it is certified extract, the company secretary signature is mandatory or not. And if it is resolution passed by the board of directors, I have heard that the company secretary is not mandatory. The directors is enough.
Directors, yeah. I don't see major difference between the two. Even the fact that it is a certified extract, still the directors can issue the board resolution, because in the authentication of documents, right, what the Companies Act says is a director or secretary or the authorized signatories, right? If you go into that, in that sense also, it doesn't matter as to the wordings don't matter at all. And I don't think at all that will be perhaps a point which will come make a point to challenge a board resolution. It is very unlikely. So perhaps I don't see any difference in the wordings. Perhaps to say, if it is certified extract, the secretary has to sign, and if it is not, the director can sign. To that extent, well, perhaps I don't agree, but the requirement is the signature. Whatever the wording is, you will need to make sure that the proper board resolution is passed. And what is more important is, we are not actually authorized to go and see the minute books, but in instances we have come across this. To sum up with your question, wordings don't matter to see whether the director or a secretary or who has to sign. But what is more important is, we actually had a problem, a matter where there was a dispute between the directors, right? When there was a dispute between the directors, and we were informed of the dispute of the directors, and there was a board resolution forwarded to us, right? It was perfect. But at that moment, we went one step ahead, right? And we requested from the secretary the minutes. We requested the minutes from the secretary, and the particular director's signature over the, because when the minutes are done, all directors sign, right? Sometimes in some companies only the chairman signs, but in some companies all the directors sign. In this particular instance, in this particular company, that there had been a practice where all the directors signed the document, right? So we went and requested a copy of that also, because the company secretary will always issue us an extract, right? So we want to see whether actually this meeting had taken place. So when we requested, the company secretary didn't hesitate. So we took that also into the consideration, and we acted according to the board resolution. I think that is more important rather than perhaps going behind words. Is it clear to you?
Yes.
Madam,
Yes.
Registration of a charge.
Yes.
Is it normal 21 days or 21 working days?
Working days. It goes as working days.
So Saturday, Sunday can be?
Saturday.
Only the
Yeah.
Sunday?
Only Sunday is excluded. Saturday is also a working day for the ROC. Next week, we are going to talk about solvency. We are going to talk about the stated capital, shares, distributions, amalgamations, ranking of claims, meetings, and winding up under the Companies Act, which are I will touch, which are more relevant to you. I will touch a little more on winding up, because these days I'm sure your NPA customers, if they are looking at winding ups or perhaps amalgamations or perhaps appointing managers or administrators to the company, what sort of recourse that the banks would have under the Companies Act. I will just touch on those things as well, as to and also as to what the companies could do when the companies are in a distressed position, that is a similar situation like this, whether they are going to close the business or whether they are going to revive the business, what are the provisions they have, and how well we could perhaps help them safeguarding our rights. I will touch on those as well. Anything else that you would particularly want to know next week? Anything that you would want to know in particular in relation to this topic, rather than the ones which we discussed and which we are going to discuss next week? Are there any more questions that I could take up? So for next week, then keep your questions ready if you all have any. So I will, it's 5:25, since there are no questions, I will see you next week at the same time, and take care and be safe. Please participate actively, because I feel very bored with empty chairs. So please keep your hands being typing on the chat board, so that we can have an interactive session. Ask as many questions from me then only I'll be able to give you more, because we have come across a lot of practical problems in our day-to-day working environment, so we can share those with you. So please be active. Be an active listener rather than a passive listener. I don't know whether you all have fallen asleep. That I don't know, but I hope I see few chat on the chat box. So I would like to see more and more people chatting with me next week. Okay, then have a pleasant week and be safe. We'll wind up for now.